Video number 6, Legal Stuff, presented by Jill Mergen. Of course, I'm not a lawyer, and I'm not giving legal advice. I'm just going to go over some important legal matters implied with employment, and make sure you have a general understanding. I briefly touched on just cause in the documentation and discipline presentation. Just cause is a legal term. When an employee files a lawsuit against the employer and claims wrongful termination, the employer would likely have to answer these questions to prove just cause. Have the rules or penalties been communicated? This is covered in providing the employee with expectations, and in most cases, an employee handbook. Is the rule necessary? The rule must correlate with the job duties. Was there an actual violation? For this, you or a third party would have completed an investigation. Was the investigation conducted fairly? Your documentation will be proof of a fair process. Is there proof of guilt? Again, documentation and investigation. Is there consistent administration? This is where you need to make sure everyone is being disciplined in the same manner. Was one person given a warning and another dismissed for the same thing? You must be consistent in your administration of discipline. Finally, does the penalty fit the crime? Are you dismissing someone for illegally parking next to a fire hydrant? All these questions will be considered when determining just cause. At will is when employers can dismiss workers for any reason or no reason at all. And there are many exceptions. Actually, there's basically so many exceptions, at will doesn't really apply to most situations. In the next several slides, we will review acts passed by Congress. These are important events in history, and this legislation protects employees' rights. This is the Civil Rights Act of 1964. You're probably very well familiar with this. The Immigration Reform and Control Act forbids discrimination, including termination as a result of citizenship status. There is, of course, the Age Discrimination Act, which prohibits discrimination of individuals who are 40 years old or older. Americans with Disabilities Act prohibits discrimination, including termination based on physical or mental abilities. Occupational Safety and Health Act, as also OSHA, forbids terminating employees for refusing to work when death or serious injury is imminent. There are other important legal issues, such as when an employee agrees to employment, a contract is created and the employee cannot be fired except for just cause. This is also true of specially contracted employees, like those who belong to unions. There are also various whistleblowing acts that protect employees from being terminated for reporting alleged employer violations of statutory policy. Defamation occurs when an employee is disciplined, demoted, or discharged, and the company tells either insiders or outsiders why. Your general position should be always not to disclose an employee's discipline and why. The only time it would be okay in a court of law is if the employer could demonstrate qualified privilege and prove the company is trying to protect itself from similar actions by other employees. I think the take-home message is, or at least for me, never discuss private matters of discipline with anyone who doesn't need to know. Then you're covered. Employer notification. As a supervisor, once an employee tells you something, the company is considered notified. I have a little story to tell about this one. Several years ago, I was leaving for the day with an office assistant I worked with, though not a supervisor of. And she was telling me this funny story about how one of the engineers she worked for groped her bottom, and she threatened to rip his arm off and beat him with it. While the story was very funny, I was conflicted that night because I knew what she described was an incident of sexual harassment. The next day, I pulled her aside and I explained that I had to report the incident because when she told me the story, she was telling a supervisor of the company, and therefore the company was legally considered notified. Most supervisors don't know this. She was upset. She didn't want him to get in trouble, and she felt like there was no harm done. But I explained to her if one day something bad went down between them and ended up in court, a very smart lawyer would ask if anyone in management was ever notified of the harassment, and my name would come up. I could be held personally liable for not protecting her, and I had an obligation to the company to report the incident, so I did. As you can imagine, it was really awkward, but I had to report it as a supervisor, and if you ever run into this type of situation, you have to as well. Now that we are thinking with our legal brains, we will run through some legal scenarios for discussion. The next video presentation is number 7, Conflict Management.